Lightning like Steve McQueen. I'm in the fast lane when the light turns green. And I built tough, I ain't nothing but grit. Cause I made rugged blood, sweat, and spit. Yeah, like a horse I fly. Better push yourself in for a bumpy ride. I like to play hard, but I work harder. And I weather the storm cause I'm built stronger.
What is up, ladies and gentlemen? We are back. We are live. It is the Freight Coach Morning Show, the top morning show in transportation, coming to you guys every single weekday, 8:30 a.m. Pacific, 10:30 Central, to break down some industry headlines, and most importantly, provide some actual insight into what you can do with all of this information. If this is your first time tuning in, welcome. This is the real side of freight, ladies and gentlemen, and I say that every single day, and what do I mean by that? I mean, I only speak to transportation professionals on this show, as well as my twice-a-week long-form podcast, because I want to talk to the right individuals who have done what you're looking to do or who are currently doing what you're trying to achieve. So you can take that information, apply it, utilize it, and see a meaningful difference in your business and your life. It's one of the many, many reasons why I proudly fly that American flag behind me every single day. A, we're the greatest nation on earth, but B, I'm living my American dream, and I want to help each and every one of you live yours as well. It is Hump Day. Corey Buchan, happy Hump Day to you. Bill McIntyre watching over on YouTube. What's going on, man? Good morning, everyone. Sonny Sharma, Orange Shirt Gang in the house. I got a very, very special guest for you guys here today. He's been on the show a bunch of times. He's kind of my resident legal expert because he doesn't bill me for his time, which is always great. My attorneys bill me a lot of money, but they're worth it. And you might need an attorney if you find yourself in the topic of what we're going to be talking about here today. So without further ado, Matt Leffler, a.k.a. Armchair Attorney, back on the show. What is up, my man?
Thank you for having me, Chris. I'm happy to be back talking about law. And I think what we're going to talk about today, this specific case with Global Trans, if you are a freight broker and you're operating in anywhere in the United States, this case is one that you must understand. This is the most important case for brokers that is pending right now in the country. And I'm excited to kind of dive into the nuances of it.
Yeah, you know, I look at a lot. I see, okay. I get kind of fired up about this shit because I see like all the the freight brokers, posting on social media and like all the bickering and back and forth. And it kind of seems like a lot of people think that they're fucking immune from a lot of recourse, legally speaking, or repercussions. Like you think like, oh, I have nothing to do with this. I'll do and say whatever I want. These motherfuckers have to listen to me. And yeah, LinkedIn's going to devalue my thing because I swore. All right. That goes on. But you know what? I keep it real. I believe in the First Amendment, you guys. The Constitution is a very powerful thing. Anyways, back to what we're talking about here. There's a lot of people who do and say things and think that it can't tie them in to a future lawsuit. I mean, C.H. Robinson gets a bad rap out here, but they're the largest freight brokerage. They're in a lot of lawsuits here. You guys, not current. I don't know of any current or pending ones, but there is a lot of things that you can learn from these situations because C.H. Robinson's brought in a lot of look at what's happening, which I think is an unjust lawsuit of Warner getting sued for $100 million about a driver who didn't do anything wrong and oncoming traffic from the other side of the freeway crossed the freeway and hit that Warner truck. But again, like, this is real, you guys. Like this is what can happen out there.
Yeah, I think that's a great way to begin to build the understanding of what this Global Trans case is about. Let's start with Werner. So the Werner case is in Texas. What happened there was a Werner driver, brand new, been working for about a week or so, driving below the posted speed limit, never loses control. Another car in the opposite direction, a pickup truck, loses control, crosses the median, collides head on with that driver from Werner. And the question was, who's responsible? And ultimately, the jury came back saying that Werner was mostly responsible, over a 70% of the liability. And that verdict, when you factor in the interest that's been accruing based on the verdict happening, is well over $100 million. Now, take that number, $100 million, and say, could a freight broker be responsible for that same level of liability? And the answer is maybe. That's what makes this case with Global Trans so fascinating. So you brought up C.H. Robinson. Many of your viewers and the folks that are watching and listening to this thing across the globe would think, wait, C.H. Robinson, that was that case a couple years ago where someone lost control and they sued the motor carrier and they sued the broker, C.H. Robinson. And Robinson fought it saying, hey, we are exempt from liability. We have federal preemption under the statute called F4A. And it went to the Ninth Circuit Court of Appeals. And then Ninth Circuit said, actually, you could be responsible for that, C.H. Robinson. And so Robinson, as any good company would do, appealed to the Supreme Court of the United States, the SCOTUS, we call it. And SCOTUS said, no, we're not interested in this case. But now we talk about Global Trans. Global Trans, same set of facts, kind of. It's in Illinois. It's in the Seventh Circuit Court of Appeals. And in that case, it was found that Global Trans was not responsible. They actually did get this F4A preemption. And F4A has to do with pricing, route and service, and there's this exemption for safety. So what we have right now is two circuit courts that are conflicting. The Ninth Circuit, which is California and Washington and Oregon, and then you have the Seventh Circuit, which is Illinois, Indiana, Wisconsin, that kind of thing. And when you have a conflict among the circuits, that's when SCOTUS gets interested. So if you're a freight broker and there's a catastrophic accident that happens in California, you could be held responsible. If it happens in Illinois, probably not. So this is what's actually at stake here is, what do you do when different circuits come up with different answers on the same set of law, the same understanding of the statute? That's what we're talking about here.
Yeah, it's because I actually broke this article down a couple months back when it kind of came out about this specific case, right? But this one you guys that we're talking about, it is from FreightWaves, and it's Global Trans wants Supreme Court to punt on broker liability issue. And then it wants more time to pass, to let more time pass and possible more legal decisions to come down before the 9 justices weigh in on the question of broker liability. Global Trans argues that the High Court granting, what is certiorari review?
Certiorari. So this is
yeah, there we go.
Yeah,
I love public school, you guys.
Yeah, no, we learn these things, how you say certiorari. So here's what it's all about. The Supreme Court of the United States does not have to take a case. There are a very small subset of cases that they must take. Like if 2 states say, this is my land, though that goes to the Supreme Court, do not pass go, you're going. But if you're in the Supreme Court of the United States, you get to choose what cases you take. And what ends up happening is, as you kind of mentioned, C.H. Robinson's like, please take this case in their thing in the Ninth Circuit. In this case, the Global Trans case, Global Trans won at the Seventh Circuit. They're like, hey, slow down. This is fine. We got an outcome that we like. Why would we jeopardize that by going to the Supreme Court? So their argument here is, let's just slow it down. And so when you are asking the Supreme Court to listen to your case, it's a petition. You're asking the court for certiorari to grant the ability to go and talk. Now, what Global Trans did is they filed a motion, a brief, and their brief says, don't take it. Don't grant certiorari. Let us just keep the status quo, and we'll see what happens in the other circuits.
Yeah, because it does talk about the Miller versus Robinson case out there, and and again, you guys, that's the one that Matt was alluding to earlier, because it left a driver, a quadriplegic, or a passenger in a car. Excuse me, let me phrase that, because sometimes some of these attorneys for some of these companies of these articles that we break down like to potentially may or may not email the host of this show and say, you got your facts wrong. So I'm trying to, protect myself so I don't have to hire an attorney. Anyways, back to what we're talking about. I think that, again, these are the things, these are precedent setting cases that will affect you, even the one person operation that's starting to fight to build your business, right? And
to build off that, Chris, like an insurance company has to understand the risk of having you as a client. And so if you're living in a jurisdiction or you're moving freight in jurisdictions where you as an organization could be held responsible, that's what's going to offset, that's going to increase your premiums. To talk about insurance just a little bit more, the minimum requirements under the FMCSA for insuring your truck is generally about $750,000, which is a lot of money. But if you hurt somebody, you kill somebody, you maim somebody, that's not going to cover it. Like, it's not going to. So plaintiff attorneys are always looking and saying, who else can I go after? Who else do I have an opportunity to go after their pockets? And these brokers, these big ones, have very deep pockets. And for smaller brokers, you may not have the same pockets, but your liability is identical to C.H. Robinson or identical to Global Trans. So if you're not paying attention This is where you can get into a lot of trouble. They also talk about the case in the 11th Circuit. That's the Landstar case. We've talked about that case before, where someone kind of fraudulently misrepresents that they're representing Landstar. They take the load, they disappear, and they never see the load again. That same argument of F4A was advanced, saying, hey, we're not held responsible for what happened in this moment. Like, they stole it, that's on them. But the 11th Circuit followed the 7th. They both agree that F4A preempts the ability to sue the broker, unlike the 9th, which is clearly saying you can sue the broker. And that's what makes this thing so very interesting.
I agree. Like, because I'm looking through this, and again, this is a good article because it really breaks down what's Matt's talking about here. And then in that Miller versus Robinson case, excuse me, the lower court of appeals for the 7th Circuit said Global Trans was protected by the safety exemption. The 9th Circuit concluded that in Miller versus Robinson, that the facts of the two cases are identical, and a driver hired by a brokerage is involved in an accident. There is a death in one instance and paralyzing injury in the other. That's about the only difference. So how do you, when you hear something like that, Matt, because again, how many people out there? I have multiple truckloads moving today, right? Mm-hmm. How many other people out there listening to this show have truckloads moving today? What are you like? Are you thinking? And again, this can go back down to carrier selection. This can go back down to a multitude of other things, because again, don't quote me, but in the Miller versus Robinson case, that's where they were found liable, is that Robinson, it was their carrier standards that allowed that driver to be put on that specific shipment.
Yeah, so let's talk about the theory of liability that we're talking about. So all of this is based around this thing called negligence. And negligence, really broken down, is you owe someone a duty, some obligation, and you've broken the obligation and you've caused some terrible thing to happen, or your lack of care has caused some terrible thing to happen. And that's what happened for both C.H. Robinson. That's what happened with Global Trans. The argument is, hey, we get it. The motor carrier, the truck driver, they made the mistake. They're the one that did the wrong thing. But you, the broker, selected somebody that wasn't competent. Maybe they were a chameleon carrier. Maybe they didn't have enough training. Maybe they had a bunch of violations and we didn't address those. And the question that so many brokers are faced with is they say, okay, what do I have to do to not be negligent in hiring a truck driver? And there's no clear answer. Like, there is no, like, if you do this and this and this, you're never going to be responsible. That is not how this works. It's a very fact-intensive investigation. And when lawyers are talking to people that are, freight brokers trying to understand your carrier selection process, we want to understand, is there a pattern or practice of you being careless? Are you just going with the cheapest? Are you doing some level of additional vetting? If you're just relying on FMCSA data, you're probably not doing enough. So this is this reality. If you're a broker, you have no clarity as to whether you're going to be found responsible, and you have no clarity as if you're doing enough, because there is no line in the sand that says do this and you're going to be okay. So if I'm a broker today or if I'm advising a client who's a broker, you better have insurance. You better assume that possibility of your liability is an inevitability, because if you're found to be responsible in that case, like Werner, $100 million, you're bankrupt. You're bankrupt today. And we have to be very careful with how we approach this. So for Global Trans, they want to wait. They want things to percolate, give it some time, because that's in their interest now. But if I'm a freight broker, I want SCOTUS to pick this case up. I want the Supreme Court to weigh in and say, definitively, across all jurisdictions, this is what happens in the case of a catastrophic injury, and you're bringing a negligent hiring claim.
So you brought up the FMCSA, and I want to ask, from your perspective, how is the FMCSA, the governing body, the agency that sets safety standards for carriers, how are they seemingly immune from every single lawsuit? Because if I was an attorney, which I'm not, I would argue that we are, and I represented a broker. My main argument would be we're selecting a carrier based on the data that the government said was an acceptable carrier. Why don't you see more of that?
So the FMCSA, number one, has, their sovereign immunity. You're not going to be able to sue them necessarily and say, hey, you're not doing a good job making things safer. But the reality is, this is a very dangerous business. I mean, even in
Mhm.
the best circumstances,
Yeah.
driving a truck is the number 7 most dangerous job in the country. And if we want to really understand safety and the goal of safety, all you have to do is look at the International Road Check, where you have 1 in 5 commercial vehicles fail. So we
Mhm.
don't really have, there's so many people after deregulation that pop up, get their, the barriers to enter are so low, and you can jump into the business either as a broker or as a motor carrier. And that's kind of a feature, not a bug of the system. And everything after deregulation has been, how can I shield myself from liability? And that's the rise of the brokerage industry. That's the rise of the independent contractor model. And that's how shippers try to find ways to be immune. So back to the C.H. Robinson case. Costco hires Robinson to move a load. Robinson selects a carrier who ultimately is a chameleon carrier. They change their
Yep.
authorizations and everything, and then they get into an accident. They're not suing Costco. Like, they could try, but Costco's gonna be like, nope, ain't happening. So it becomes this, like, who's really responsible, the driver or the brokerage? And it depends on where you live as to see whether or not you're going to be found responsible or could be found responsible.
Dude, it's 'cause this is the stuff that, again, it never gets any attention because it's not sexy to talk about this, right? Like, this is one of those situations where, it's not a meme or something else to get a bunch of laughs, but like these are the repercussions of a lot of, I think what the core fundamental issue is inside of transportation is training, right? It is talking to your reps about, because, like, let me preface, uh, bad things happen in the real world, you guys. All right. People die. People get killed. Like, mistakes have consequences in the real world. But I look at it as, how can you go back? How would you advise, from your perspective, a broker where you see cases like this against Robinson and Warner and Global Trans? What should they be doing internally to maybe have proof that in the event that this happens again in the future, we did everything in our power to ensure that this didn't happen?
I think that's a great question, and I'll preface this with my typical disclaimer. I'm not your lawyer. If you're watching and listening, I'm not representing you. I'm not giving you legal advice. I'm sharing what I would think of as some kind of best practices. And to your point, it really does boil back to training. Now, if you look at what it takes to become a commercial vehicle driver, to operate a Class 8 truck in the United States, it's a couple months. You're not trained on how to drive at night. You're not trained how to drive in the mountains. There's a level of, let's just get the meat into the grinder and let's start processing the materials. You
Yeah.
have to be cognizant of safety. You have to be, safety is a very important priority. For the brokerage industry, oh my goodness, systematize your processes. Don't deviate from them. If you have a process of how you onboard a motor carrier and all the vetting that you do, the moment you deviate, if I'm a plaintiff attorney, I'm salivating, because your lack of care or your lack of consistency is exactly how I take the dagger and stab it into your stomach and bleed you dry. So you have to be cognizant of how you train, how you go to market. I'd also say you better have smart insurance agents, whether they're agents or you're working directly with an insurer.
Yeah.
You better understand your liability and how you can navigate that as best as possible.
So, speaking of liability, how are you surprised that you don't see some of the software providers that are rating carriers and everything? Do you think it's inevitable that one of them are event? Because, like, if I was a broker and I hired company A to do all of this, and then I used that data, made a decision, or are they, pretty much removed from liability, even though it was your decision was based on the information that they provided in those moments? Because, again, I think, like, with the rise of technology that's out there, because this is the biggest problem that I see with, like, AI and stuff like that, is it's not regulated. And that's a massive, massive pending issue that could happen. So do you see that from a legal perspective? And again, put your disclaimer,
Yeah.
not a lawyer, not advice or anything like that.
Yeah.
Do you see that being a reality at some point, where we used company A to make this decision? Their information was bad. They got that information from the FMCSA or whatever, or however people compile
Yeah.
that data. Do you see that becoming a thing?
Absolutely. So I think as time goes on, if you're not doing some level of additional vetting outside of just going to the safer database, if you're
Yeah.
getting, whether it's Carrier Sure, Highway, or Carrier 411, or all the technologies that are out there, that has got to be part of your process. But that alone isn't enough. Now, if you rely exclusively on some data company, and that data company has somehow represented that that's all you need to use. There's certainly, I could imagine a world where there might be product liability saying, hey, the only reason I was found liable was because I relied on your stuff. These software companies, what they do, to be very clear, is generally scrape data from Safer. They add some level of rating system. Maybe it's a peer-to-peer rating system. Maybe it's some other, thing they pull from some credit rating agency. So they're not doing anything magical. Sometimes they can pull telematics, and that might be useful too. But the reality is, you as a broker have to know your motor carriers. If you live this business saying, I'm just going to do transactional, I'll get a carrier, I'll move it, I'll never talk to them again, you are risking being found to be in a position you don't want to be in. Know who they are and make sure they have the right insurance, make sure they have the right training, and ultimately, hopefully, that partnership allows you to not be found liable if something catastrophic happens. But rest assured, even if everything goes right, you still get sued. Like, there's two things and this is, I know we're getting close on the time, but there's a distinction I want to make for everybody. There are two things that insurance does for you. There's two things. There's a duty to indemnify, which we all know, which is insurance company pays the thing on your behalf. There's also the duty to defend. And the duty to defend is when the insurance company hires a lawyer, pays the lawyer, and makes the lawyer go to court and advocate on your behalf. There are a lot of brokers that I've encountered in my career that don't carry insurance for liability. They just say, it's up to the motor carrier. I don't need to carry it. And if you're in that situation and you get sued, even if you might have won, you're done. You're toast. You're toast. That litigation is $20,000, $30,000 a month. So having insurance as a baseline, so important.
Yeah, I don't think enough people look at the risk analysis of what not having insurance is. And and again, like, I think that this is what needs to be fixed. I currently feel my is that freight brokers should be required by law to carry cargo and liability insurance to operate. And I feel like even dispatch services, because again, I'm all about setting that standard across the board, right? Like, dispatch companies that are out there that are finding freight on behalf of carriers and everything, they need to carry insurance and everything as well. I think that there needs to be a set standard out here because of what you're talking about right here, Matt, because it's like, you can't sit here and say, we had a bad day, or, well, the data that we used said this. No, that's irrelevant, right? And like, you're talking about litigation costing $20,000, $30,000 a month. Like, those attorneys, you guys hope you have a bad day and maybe looked over something, and your processes don't back up what you're saying because you don't have any processes. And then those attorneys will dig that down, and then they will find you, and then you're liable. And then what? One mistake costs you your life. Like, livelihood, excuse me.
Yeah, and this is why I think it's also important to note that I fundamentally believe motor carriers should be required to carry higher levels of insurance. That's a very controversial thing to say, because it is an expensive thing for a motor carrier in a market where motor carriers aren't making a ton of money. But having inadequate insurance is a very difficult thing to put in place. And then also, to your point, if you're in litigation and you can say it's just the driver had a bad day, that is a great victory for you. If you are able to say it was just a one-off thing, but the reality is, and that's what we lawyers get paid to do, is to understand, can I take the bad day and say it's a pattern and a practice? Because if I can make that jump from one bad day to a pattern and practice, your liability goes up very significantly. And that should make everybody pause, because again, we put people in bankruptcy. That's what we do. If I don't get paid, I'm going to liquidate your assets. I'm going to go after your house and your cars and your bank accounts, and I will get paid. I will get paid. So it's important for us to understand this. And that's why I go back to this central idea of global trans: clarity versus uncertainty. Global trans, in this case, going to the Supreme Court, is arguing we would prefer to keep it uncertain. Let the circuits fight some more. Give us time. Let us be immune from being held responsible. For me, I want clarity. I don't care who wins, who loses. I want to have a final rule that goes across all the United States that is clearly defining who is responsible if you have what would arguably be a negligent hiring sort of case.
Put your speculative hat on here, because again, this is pure speculation. Why would they argue for that stance, to let it kind of ride out, let there not be a clear line in the sand?
Oh, because there's a chance they could lose. I mean, this is fundamentally, the Global Trans understands that our Supreme Court is one of the most conservative we've had in a while. It's a very interesting court, and chances are very likely, in my opinion, that the Supreme Court would follow what the Seventh Circuit put in place with Global Trans, which is to say, Global Trans as a broker is not responsible for a motor carrier doing something terrifying. But if it's a 10% chance you lose at the Supreme Court, then it's that giant bucket of liability you have to pay out. So for what Global Trans has argued is saying, hey, we understand the circuits are conflicting. The Ninth Circuit and the Seventh Circuit are absolutely cannot be the same. They're completely different. But maybe the Ninth Circuit will look at what the Seventh Circuit did and say, we were wrong. We should do what the Seventh Circuit does. And their argument is essentially delay. They call it percolating. That's a very fun way to say, let's not do anything and see what happens. Because the next case we see like this might be a year away or 2 years away or 3 years away. And by that point, they're not going to have to pay ye anything because they were found to be not responsible. They were preempted. They didn't have to get pay out anything for ye. So this is why I think Global Trans is making the argument of, hey, don't be hasty. We have time. Let it percolate. Give it some moments. It'll be fine. Just a little while.
But I don't know, man. Like, what if something happens more catastrophic and now they can flip and then somebody could appeal? I mean, or is that case pretty much done? Or could the ye attorneys appeal that?
This is the final stage. So when you have exhausted every other thing you can possibly do, you go to the Supreme Court.
Yeah,
and
for
if
sure.
Supreme Court says no, then you're done. You're toast. Just like C.H. Robinson. Robinson desperately wanted the Supreme Court to weigh in on their case with Miller. And the Supreme Court's like, this isn't right. There's not enough controversy. But ultimately, maybe with this case, Global Trans and the C.H. Robinson being so diametrically opposed, I think SCOTUS takes it up. And I urge them to do that because we as an industry need clarity. If I'm an insurance broker or I'm an insurance agent and I have brokers moving stuff everywhere, how in the world do I navigate your liability, not knowing how every circuit differs? You want to have that level of clarity. And that's what's so important.
Oh, man. It's, I think of all the instances out there where people aren't insured. Like Chandler says here, some carriers don't have general liability. Why? That is so risky. How many people out there are sending shipments across state lines and everything where they didn't vet their providers? They might not have insurance at all. They might have a valid driver's license. There's a lot of real risks here, right? And this is why I bring Matt on as often as I do, is to talk about the realities and the repercussions of your actions and or inactions in those moments. It's not always about just booking a load, right? Like or cold calling and chest bumping and all that fucking ping pong and all that bullshit that everybody wants to get out there, because like, is the company you're working for actually covered in these moments? And that's what I would want to know if I was an employee, right? I would want to know that. And Stuart, the hobby trucker, says, how much of it is ignorance? I think a lot of it is ignorance. And again, I'm not an attorney. Matt doesn't offer legal advice. He is an attorney, but I don't think that argument stands up in course of I didn't know.
No. And I think you can be forgiven for not understanding the risks that are in front of you, because this is incredibly complicated stuff. We don't go into the business thinking, if I get a contractor to perform a service for me and they don't do a good job, I could be held responsible. We don't think of it that way. We think of the broker as providing, this service of connecting these things. And we're not telling the driver where to go. Like, not saying this is the route you have to take. We're not saying what speed you have to drive. We are an arm length transaction, but that's not how certain circuits see it. And we live in a federal system, and our federal system has a court system that can have conflicting understandings of the same statute. And it's words. It is just words. And if those words mean different things to different appellate courts, what in the world do? You have to ask SCOTUS for clarity. They're the only ones outside of Congress. And God bless you if you think Congress will fix this, because they're not going to do that.
We're not
So
we're
does
not
Cam.
getting into that on this show, Matt. We talk about freight, and we don't need to get into that because we can go for another 30 minutes and talk about how Congress won't do anything.
Well, I want to see Grace Sharkey's comment. I want to talk about what Grace is talking about.
What does she say?
So
what if the TIA told me? You mean
that's a dig against TQL for misclassifying brokers as exempt when they're non-exempt, when they're entry-level employees. Look, this is a difficult business. This has never been easy. No one gets into this industry going, oh, this will be an easy way to make money. This is an incredibly...
There's a lot of people who think that, but
they think that until they get here. Like, oh my gosh, this is a nightmare. Yeah. This industry is hard. And we need our Supreme Court to understand when there is something so anathema to our industry than the lack of consistency in our regulators. And if we can say, without a shadow of a doubt, if something happens in Illinois and California, and it's the exact same set of facts, the outcome is different. You don't want that. You want consistency because that's what drives prices in a way that we can consistently understand. That's what risk mitigation is all about.
Matt, I appreciate you. I really do. Thank you for coming on. Robert Kelly says, thank you for helping me understand freight. My company, Forum Mobility, is helping truckers in California meet the mandates around zero emissions, and the Freight Coach has helped me and my team understand the market and the challenges. Robert, I appreciate that feedback, man. At the end of the day, you guys, that's literally all that this show is designed for, is just to put information out there that people can use and apply to their business and, and make it work and help those individuals. Because I think of the time of my dad starting his trucking company back in the day and everything else, and what a lot of the people out there, kind of what Stuart, the hobby trucker, is talking about, of people not knowing. This is why we have these conversations, because I want to keep people in business, plain and simple. I want there to always be talk about how all these drivers are going out and starting their American dream and building their businesses up and going out and going for it. Just like the same thing on the brokerage. I want to see that. I want to see more of that, but I also want to see real information from people that have done it, that they can put in there to kind of help. And again, this isn't going to sit here and say that all your mistakes are going to go away, because frankly, you can give the keys to the castle to some people and they're not going to do anything with it. But this at least puts a catalog of information out there that people can be like, actually make sound decisions on. And that's what it's all about. So.
Absolutely. I mean, this is a family business. My father my father was at Roadway back in 76. My grandpa was running grain in the Midwest in the 60s and 70s. We're all trying to survive. And it's important for people to know what risks are in front of you, because if you don't, you will find out the hard way.
Yeah. And we didn't even talk about the Teamsters. I mean, anyways, you guys, that's going to be it for today. We will be back tomorrow. I have another guest coming on tomorrow. As always, you guys, if you guys got value in what you heard, subscribe to the show, you guys. Share it out there. That's how we're the top ranked podcast in transportation, is because of each and every one of you. And the fact that if you see value, your network will see value as well. I appreciate you guys. I love you guys. And we'll be talking to you soon.